Yeah, we have the first issue. Not for potential.
City Court, City of Detroit, State of Michigan, now in session with the Honorable Ronald Giles presiding.
Calling case number 2357245, the people of the state of Michigan versus Charles Blue. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for a probable cause.
Good morning, Your Honor. Philip Henderson on behalf of the people, P86029.
Good morning, Judge. Neighborhood Defender Service by Jackie Pilkowitz, P81653. On behalf of Charles Blue, I'd ask that the court waive his presence for purposes of this PCC. I just spoke with him yesterday.
Maybe present for the purpose of this hearing.
Your Honor, I am in receipt of.
Go ahead.
I am in receipt of some digital discovery. Just so Mr. Henderson is aware, I have received the body camera footage for an officer Malik, but I do not have any body camera footage from other officers, including Mobson, who I believe is the officer that effectuated the arrest. I will prepare an order for the court to sign today, and otherwise we'll just need a preliminary exam date.
July 3rd at 9 o'clock.
Judge, I'm out next week. I have an exam with you on the 7th. We squeezed that one in. But my schedule is getting really, really tight. If the court could accommodate a July 10th exam first thing, I will be there.
Pushing it off a little further than I want to go.
I understand, Judge.
Can we do it right before the other? Oh, no, you got something else.
Yeah,
Right
that'll.
after.
Yeah, we can set it for 11 or 11:30. The other one is a capital with 2 co-defendants, so that one realistically might take about an hour.
We'll
If
set
we
it
want
for
to
11
set.
o'clock.
Okay, sounds good.
What day?
Okay.
That's July 7th, 11 o'clock.
I have nothing further, Judge.
Okay. All right, then that'll complete the hearing. Thank you.
Thank you.
Yeah, that's okay. Oh, it is?
Yeah.
We have 2 PCCs today.
That's it. No pain, no gain. Okay. I hate that city, I hate that city, but it's true.
Doctors told me they've been lying to us.
Yeah, that's all. So. Already changed. Oh, they brought one in. They put it way
Oh,
over here.
yeah.
I just told them. They put
But you
it
know
close.
what? I don't like that they put it over there.
Why put it so
Why did they
close?
put it in the corner?
Right so close to the judge. And then you got this thing right here. Oh, God, they did that. I mean,
It's, what's his name?
I
Nar.
would pick up. I ain't out of my pay.
You say you ain't moving it?
I see that's out of my pay scale. Right? Something happened.
Yeah, that's true.
They got.
I'm sure that ain't Mike.
The chance to be the first.
Yeah, that's the water.
Yeah, that's.
No, I thought you was. I have. Oh.
Oh, your client stuck in there?
He shouldn't be stuck. I told him he could leave the breakout room, but don't press leave meeting. So he should be joining. There he is.
All right. You ready, Ms. Henderson?
Yes, we are.
Okay. You ready, Kim?
Yeah.
Calling case number 23-56646. The people of the state of Michigan versus Desmond Benson. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for a probable cause now.
Philip Henderson on behalf of the people, P 86029.
Attorney Sydney Henderson with NDS P84839, appearing on behalf of Mr. Benson. Mr. Benson, could you state your full name for the record?
My name is Desmond Tyler Lamar Benson.
All right, morning, Mr. Benson, just so you know, in the future, I don't do sweats. I don't do t-shirts or anything like that in my courtroom. A shirt with a collar, please, all right?
Of course.
Thank you. All right, Ms. Henderson,
Yes, Your Honor, at this time, we have received all discovery. We wanted to know whether the people have an offer for Mr. Benson.
I believe the offers have been pulled, so it was not accepted, and so it's been pulled.
Yes, I did speak to Mr. Benson. He didn't understand exactly what height it was, so we had a chance to review it, and he did want to consider it if your office was still for the 18 months probation.
Okay, our office policy is to send it back to Judge Robbins and then do it there if the court's amenable to that.
I'm sorry, I didn't exactly understand. So are you saying the off the table or still on the table?
he said their office policy is to send it back to Judge Robbins
Okay,
and do, you know, the problem is if it don't go through and it comes back to me, you're gonna put me way over my time limit. I'm not gonna be real happy about that.
okay,
So if there's a strong possibility that, you know, this is gonna go through, I'll send it back. Otherwise, I'm not gonna waste my time.
it will go through, Your Honor. He does want to accept that offer.
All right. Send it back. We gotta get a date from Judge Robbins.
Yeah.
You can just tell them that they don't accept the offer, so. Like, as soon as they can get it in.
So we got a So they're here. So. Oh, she. You don't have- Yes. That's right. The time, that's right. Oh, you do all yours at 8:30. Okay, all right, thank you. July 10th at 8:30.
Thank you.
All right, I'll conclude the hearing.
Thank
So
you.
that's what
That's what Judge Robbins, you got the date, Mr. Benson?
Yes, sir.
Okay,
Have a good day. Thank you.
all right, you too, thank you.
You can log out.
Out of the whole thing?
Yep, you can exit the meeting. I'll send you a text message.
Okay.
Oh, that's on our PCCs. Justin Pitts.
See the new pool over there?
Huh?
So, Rob, you see the new pool?
Oh,
Pool.
did you taste the water? Did you get some water, Joe?
Brand new.
Did you get some water?
Yeah.
Oh. Y'all scary.
I'll test it out, don't worry.
I tested, I need some water too.
But you know, one thing we know, if it doesn't taste good, it's not
I
water
can't-
fountain, it's water. So,
I can't see it from back there. I
know-
look for it.
I know, that's what I.
Yeah, because they put it over here when they should have put it right here. They should put it in the corner.
It's like,
Yes.
And the line say.
Huh?
What is it?
It's nice and cold.
Which is good. Judge, I'll say thank you very much.
yeah, it's brand new.
You didn't want no water, did you, Judge?
No, I'm all right. I thought Ronald was trying to set me up, he has bottled water. He is water over here. I'm like,
It's all the time you pass the ball back.
What time did you get power? What time did you get power?
I don't.
Oh, you still
You
don't
still
want water?
living?
Oh, no.
They said Wednesday, that's in Detroit.
Wednesday.
Today, well, no.
That's tomorrow. Wednesday is tomorrow.
They said by Wednesday, everybody should have that back on. What they tell you, Judge?
Well, this morning they sent me another text that they gave me today's date, so we'll see.
Mine came back on at about 6:30. I went home and I pressed the button for my garage to open, and it opened, I said, okay, I got power. I went in the house, wasn't no power. I forgot I got a new garage door opener.
With battery.
Yeah, got the backup. I'm disappointed. I bet you were. But they never gave me a time. It just came back on. You gave me that same thing about that day.
Yeah, they didn't give me a date, they didn't give a time. Yeah, they waited until midnight to send me a text saying, that, we weren't able to finish it today. I'm like, no, it's midnight, you know.
I think the weather got in the way.
Yeah.
I was worried because it started raining again. I said, oh, they ain't gonna be out there in the rain.
But you got to do it.
Yeah. But I think that delayed them, the moving storm.
That's true, it was, it came down hard too. You didn't have any thoughts.
Look at, show you my puppy. This is crazy.
It's a no, yes.
Yeah, it's the same dog. So my husband has this big old bucket of like old golf balls, just golf balls. And dog is crazy about balls. So she gets in the bucket of golf balls.
Oh, that's so cute. See something cute. Oh my God. See, you took that one, right? That's good.
No, he did. And actually, you can't, can you see, she got dust and dirt all around
Yeah,
because she was trying to get the golf balls out.
Still dusty. That's funny. That is so cool.
She was like digging, like, it was funny because it seemed like it was a certain ball she wanted, because she's moving her balls all around. But she just wanted to sit in there. Like, that's crazy,
That's
y'all.
kind of cool.
She's all dirty.
That's cool. No, just something else, of course.
Yeah, she ain't there with all the balls.
Right. And she stayed in there for the longest time, just sitting there like that.
Chilling. I'm bald headed.
Right, I got all of them. Ain't nobody getting them.
Stay back. I finally got out golfing, and, I'm back to skilling.
Yes, it's not.
Oh, no, I had crossed it. I wanted to make sure she.
So you want to stop it for
There's
tomorrow?
Oh, and tomorrow too, so I give it to her.
And it is charged with count 1, police officer assaulting, resisting, obstructing. This matter is scheduled for a hearing.
Good morning, Your Honor. Philip Henderson on behalf of the people, P86029.
Good morning, Your Honor. Alyssa's the girl with the Neighborhood Defender Service on behalf of Mr. Pitts, P86432.
Speak up, Pitts. You know how to address the court?
Good morning, Your Honor. Justin Pitts.
You know how to address the court, sir?
Morning, court.
Do you know how to address the court? I don't just sweat in my courtroom.
I'll apologize.
I don't want your apology. I want your respect.
Yes, sir.
I'm not getting it. That's the problem. I got a choice. I can send you over to Wayne County, let them dress you. That's what I gotta do to get my respect.
Yes, sir.
Before I address the court, right?
Yes, sir.
Ready to see?
Your Honor, at this time, the necessary witnesses failed to appear. State is not ready to move forward.
We would move to dismiss, Your Honor.
All right, that's.
Yeah. I know. Thanks to the latest, everything
I'm like-
today, yeah.
I was looking at the date of birth.
I.
Pretty even unless I'm.
Yeah.
Morning, Mr. Sullivan.
Morning, Madam Clerk. I'm here on Ronald Crumpton. I'm sorry that I've just finished my PCCs a little late at my office, and I wanted to check in by Zoom.
Ronald Crumpton is in Judge Jefferson's courtroom. That's Judge Jefferson case.
Okay, understood. Thank you.
All right, you're welcome.
No.
Thanks, Senator.
How you doing, Your Honor?
Good morning, how you doing?
All right, sir.
Got 9:30 plan here.
Just the attorney, he says his client is on his way up.
Have a plan?
He's on the way, Judge.
I don't know what it means. It's supposed to be, 6 minutes ago.
He says he's 10 minutes away.
Well, I don't know if I'll wait that long.
It is gonna be a waiver, Judge, if you wanted to zoom in.
No, we have to be here. In-person exam.
Okay, I'm starting to get a little cold. Ryan Hills on board?
Yeah, we just wait.
Here.
Yeah, how about?
He is downstairs going through security.
Oh, yeah?
Yes, sir.
Okay.
It's on the left hand side.
Thank you.
Hmm? Huh?
Yeah, it's right.
Oh, the attorney.
Email address.
It's starting to get cold.
Yeah. I had to back up. That's too good.
Right, they can't get it right. That's the problem.
But maybe you might need to do stage a little bit. Good for him. Okay, right. See you.
He's on the way out.
It's only, 69.
Yeah, that's so wild. You gotta cut the hairs. Yes, here.
Right.
We got it.
So Ryan Hill just texted me. He said he's on the way for more.
More? For more?
Yeah,
That's
Jimmy Moore.
So that's not James.
That's what. Let me look at the file, see what the file said.
At least he's checking with me.
Right, exactly. That's it. Oh, okay. More. Yeah, I don't have Brian out here. Yeah.
Used to remember when he used to come on, he used to always seem like he was mad.
Cool, Chambers.
I had to chill him out, yes, he was over there.
Yeah.
The judge got a.
Ah.
Oh, so what'd you get?
Ready, Kim? I am. Calling case number 2357376, the people of the state of Michigan versus Anthony Millard. Defendant is charged with count 1, controlled substances, possession of cocaine, heroin, or another narcotic, less than 25 grams, habitual offender, third notice. This matter is scheduled for exam.
Good morning, Your Honor. Adam Woodcock appearing on behalf of the people, P86266.
And good morning, Your Honor. Adam Wolak, B number 55741, appearing on behalf of Mr. Flowers, who is standing to my right.
Mark, can you state your name for the record, please?
Yes, sir. Anthony Raphael Pollard.
I'll not address the court.
No, sir,
I don't do sweats in my courtroom.
Yes,
I
sir.
don't do t-shirts.
Yes,
You
sir.
can't dress in my court. Just dress you. I only got one way to do that. Send you Wayne County Jail, let them dress you. That's what I gotta do.
Yes, sir.
That's what I gotta do to get my respect. Send you Wayne County Jail, have them dress you.
Yes, sir.
Got a watch? Watch.
No, sir.
You got a phone.
Yes, sir.
That's time on the phone, right?
Yes, sir.
What time were you supposed to be here?
9:30,
What time you get here?
9:37,
Don't even try it.
9:40.
I walked out of this courtroom about 9:45.
No, I was arriving, I was passing the apartment
What time did you walk into my courtroom?
at 9:40, 9:45.
It was after 9:45, because I ain't leave here till then.
They told me not to use my phone. I didn't even look at it once I walked in the text. I do apologize about that.
Counsel.
Your Honor, today is the date and time set for a preliminary exam. I've explained to my client he has a right to hold this exam and what the people must show. At this point, he's executed a waiver form and is waiving his right to be examined.
Do I have any objections?
No objection from the people. Thank you, Judge.
Well, if you understand that you have a statutory right to preliminary exam where the state must show by probable cause the crime was committed, and by probable cause you had something to do with committing that crime. You understand that?
Yes, sir.
Anybody promise you anything or threaten
No,
in
sir.
any way to get you to waive your right to preliminary exam?
No, sir.
You're waiving your right freely and voluntarily after having opportunity to talk to your attorney about it.
Yes, sir.
You signed the waiver of examination form?
Yes, sir.
All right. Court of Finance, you freely and voluntarily waive your right to preliminary exam that is bound over Wayne County Circuit Court Criminal Division for arraignment on the information be July 11th, 2023 at 9 o'clock. All right, Bob, continue.
Thank you, Your Honor.
All right, thank you.
Oh. Thought it was at 10.
Kidding, yeah, everybody learning. Kidding, sorry. It's gonna come over this way.
Schedule's off this week. One thing about when they off for a long,
Yeah.
I remember to turn that down. You ready, Kim? Yes. Calling case number 2357394, the people of the state of Michigan versus Jimmy Moore. Defendant is charged with count 1, weapons carrying concealed, count 2, weapons, firearms, possession by a felon, count 3, weapons, felony, firearm, habitual offender court notice. This matter is here on exam.
Philip Henderson on behalf of the people, P86029.
Morning, Your Honor, Ryan Hill, P68445, on behalf of Mr. Morris, state your name, sir.
Jimmy Moore. Mr. Pleasure.
Your Honor, I've executed, my client and I have executed a waiver form.
We have no objections.
And Mr. Moore, you understand that you have a statutory right to a preliminary exam when the state must show by probable cause a crime was committed and probable cause you had something to do with committing that crime. You understand that?
Yes.
Anybody that can promise you anything or threaten you in any way, you should waive your right to your exam.
No.
You waive your right freely and voluntarily after having opportunity to talk to your attorney about it.
No.
Right? You're waiving your right freely.
I understand correctly, yes.
Okay, let me just, so the record is straight. You're waiving your right freely and voluntarily after having opportunity to talk to your attorney.
Yes.
And you signed the waiver of examination form, correct?
Yes.
All right, court will find that you freely and voluntarily waive your right to preliminary exam that is bound over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be July 11th at 9 o'clock.
Thanks, sir.
All right, anything else?
Nothing, Judge.
Here, thank you.
See you. Take care of yourself.
He'd like to speak with you.
Uh-oh. Time to next one. 11.
11 o'clock.
Who said this? Mr. Bell is here.
I ain't complaining. Tell them tight, complain, and tell them loose, they complain.
I tell you, I can't, it's always something. Pronounce 11:15. It's Thursday.
Huh?
Pronounce
What?
this Thursday.
Do what?
11:15.
Quavian. Really? Oh. I should have asked you.
I thought you had a problem with Roberto.
Huh? Roberto Romero?
Yeah, he's coming back. You got a problem. He's coming back.
Coming back.
He comes back tomorrow.
Yeah, right.
Mhm.
Because he needed an interpreter, right?
The witness did.
The witness, right? Like I said, he couldn't understand.
Yeah, I mean, he said it. He did say, I'm really nervous.
And then we got in the hall, he said, yeah, and, clerk can't do this.
Whatever. Huh? Yeah. Oh, no. Oh, really? No, I didn't know. Oh.
You can see that, like, that's interesting.
You saying he's in the cartel now?
I'm not saying it's a cartel. You don't do what you're supposed to do. You take things. You know, but. Yes.
And the defendant is here. No.
You're supposed to give that to your attorney. Yeah, and then your attorney. Yeah, just to show proof that you're working. Yeah. Yeah, send that to your attorney.
Mr. Officer on bail.
It'll be a bold time. Yes. My grade, I'm doing two meetings.
She said, "Oh,
I have yet to. But it could happen, so please give me a little bit of grace.
I will. She's gonna hold on the bill.
I thought that's what I heard. You were supposed to do the sign. Hold on. Just.
Yeah, and that's. See, I was on the job. I'm trying. It's cool. It's good. It's good. Yeah, you know, You'll see something. Yeah. She'll take yeah, yeah. Right, personally. That's all it is. Just like basketball. I ain't bad at you, it's just how do you at least so many of us out here. Think about, like, remember, like, remember Stevens? Doug Hopkins.
Parties ready on Mark Bell.
Try to keep it excited.
Parties ready on Mark Bell, calling case number 2357106. The people of the state of Michigan versus Mark Bell. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for exam.
Good morning, Your Honor. Adam Bookler appearing on behalf of the people, P86266.
Good morning, Neighborhood Defender Service by Jackie Polkowitz, P81653 on behalf of Mr. Bell, who stands to my right. Mr. Bell, will you state your name to the judge, please?
Mark Bell.
Thank you. Ready to proceed?
Yes, Judge, before I call my first witness, just ask for a mutual sequestration.
I would join in that request, Judge.
So with the exception of my officer in charge who is present and will not be testifying today.
And I have no objection.
All right, and all witnesses testifying today at trial or anytime in the future in the courtroom, Zoom, and or YouTube, or be denied that future testimony. Your acceptance should also be charged. Go ahead, first witness.
Thank you, Judge. We will call Officer Joshua Denard.
National Jail, SHUA-DENART.
You swear our affirm to the truth, whole truth, and nothing but the truth, so help you God.
I do.
Pull the door towards you. And take my hand.
Okay.
All right, sir, could you please state your name for the record?
Officer Denard,
Officer, where are you currently employed?
Trevor Police Department,
How long have you been with DPD?
approximately 3 years.
You said 3 years?
Approximately 3 years.
Okay. I'm gonna direct your attention back to May 27th of 2023. Were you in the location of 21623 Plymouth Road?
Yes,
Is that in the city of Detroit, County of Wayne?
yes.
And what is at that location?
There's a park formerly known as Rouge Park.
And were you working in a working capacity at that location on that date?
Yes, I was on duty.
Were you working alone or with a partner?
Had a partner,
What's your partner's name?
Officer Mackey.
And were you in uniform?
Yes, we were in a Class B uniform.
Okay. And were you on foot or in a patrol car?
We were on foot.
So what were you doing in the park on that date?
We were trying to maintain the peace and cut down on any type of criminal activity due to the park being overloaded.
Okay. What do you mean by overloaded?
There was upwards to 5,000 or 7,000 people at times due to an event going on.
Okay. So I'm gonna direct your attention to just after 7 PM on that date. What if anything happened that might bring us into court here today?
While we were around addressing several infractions from different individuals, as we were passing through, we observed an individual.
What did you observe? Not we.
As I was walking around and enforcing different things, I observed a male with a strong L-shaped bulge on his right side.
Okay, about how far away were you from that male when you observed that?
Probably about 3 steps.
Okay, that person that you just said that you saw, do you see them in the courtroom here today?
I do.
Could you please point to them and identify them by an article of clothing?
Individual with the pink and brown hoodie on.
Thank you, Your Honor. May the record reflect that the witness has identified the defendant, Mr. Bell. Thank you, Judge. Okay, so you said you observed it. What you said was a strong L shape. What What do you mean by that?
So a gun is formally shaped as an L. There's different angles on it, but however, they depict an L. And that was sitting on his right frontish side, it was right on the crevice of where his hip would start from his front ends.
Okay, so
Wait, hold on. This front what?
So if we went on the clock, it'd be like two o'clock, between his 2 and 3 position on his body.
Okay.
what do you do when you make this observation?
I asked the individual, I asked him if he was in possession of a CPL.
Did that individual, did Mr. Bell respond to you at all?
Yes, he reached in his pocket and retrieved his wallet and produced a CPL that was worn out and tattered. And then on his face, it had a date of 2021, is really all I could see. So I seized the gun from his person, pending a computerized investigation and validation if maybe it got updated, he just received his card for whatever reason or had the proper one on him. However, through the computer, he also turned back, expired as of 2021.
Okay, for that CPL?
Yes.
Okay, so what do you do when, after you do this investigation?
I advised him that he was placed under arrest for carrying a concealed weapon on his person, and we conveyed him to the DPC.
Thank you. Your Honor, I have no further questions for this witness.
Officer Denard, you were wearing your body camera footage, or sorry, your body camera that day,
Yes,
and to your knowledge, it was operational?
yes.
And did you personally upload the footage up to your internal server system?
Now we turn it into our supervisor, then they should dock it.
Okay, and in this case, what did you do?
Turned it into my supervisor.
Okay, and who would that be?
Don't remember on that day.
Say it again?
I do not recall who that was on that day.
So to you, as far as you know, it was working and recording at the time of the stop and arrest of Mr. Bell's person, correct?
Yes.
So if it's not working today, that would be of no fault of your own.
Say again?
Hold on.
So if the video-
Wait, what's the relevance if it's not working today?
Well, I don't have the recording, Judge. The video doesn't work. So for purposes of impeachment and laying a foundation for, this would be a discovery issue down the road. I just want to have his testimony that it was working at the time and it is no longer working.
You can't say that. You can say what he said, as far as he knew, it was working at the time. Now, whether or not it's no longer working, one, that's irrelevant to these charges. And I don't even know if he can even answer that question.
I'll move on, Judge.
All right, thank you.
So you and your partner are walking through Rouge Park, correct?
Yes,
Okay, this is around 8 o'clock at night.
give or take.
Okay, so it's still light outside because we're in May.
Yes,
And you say you see my client
yes,
with a strong L-shaped bulge,
yes,
and that's instead of a weak L-shaped bulge.
sure.
And because of that, you approach my client
Yes,
and you stop him
yes, I do.
and you ask him if he has a CPL,
Yes, I did.
and he produces that card and hands it to you.
Yes, he did.
And then you detain him at that point.
Yes,
Okay, and you take him over to your cop car.
I took him over to a person who was occupying the vehicle. We had several officers on foot, and we had others at crossing posts.
Okay, so you detain him and you walk it took you about 5 to 7 minutes to get over to the post where another officer is parked.
I can neither affirm or deny I didn't time it.
Your vehicle was not situated immediately next to Mr. Bell when you approached it, correct?
No, it was not. We were on foot apart.
So you had to walk him over to the vehicle.
Yes, I did.
And there was another officer who you have not mentioned so far operating that vehicle that's parked on the street.
Yes, he did. Yeah.
And you testified that you received lien results concerning the CPL being expired, correct?
Correct.
Okay, you yourself did not run his name in lien.
Negative, I did.
Okay, hang on, I'll ask the questions. So you went into another patrol car that you were not operating to run his name and lane? That's your testimony?
Negative. My testimony is I did walk into another patrol car that was stationary at a crossing post. He ran it, verified it, gave me a thumbs up.
Hang on, let's stop there. He ran it, verified it. Who is he ran it and verified it?
Officer Grover.
Can you spell that for the record?
Groh.
Okay, so Officer Groh ran my client's identification and CPL in lane. Correct?
Correct.
You yourself did not do that.
I did it just after that. We went back to my car. If you continue watching the body cam, and you would have saw it was also re-verified, and then there was another verification process.
At the time you placed my client under arrest, you were acting on the representations of Officer Groh, correct?
No, I was acting off of the prima facie evidence on his card that said 2021 expired.
Right.
And then I did a computerized investigation, which did not have to be done because that card is evidence enough to say that you are or are not a valid.
Your Honor, I would move to strike that. That's a legal conclusion concerning whether it's evidence enough.
Oh, so just answer the questions. We'll get through this quick. Thank you.
Just one moment, Judge. Just briefly, when you initially approached Mr. Bell and asked for his CPL, he provided it to you, correct?
Yes.
And then you reached for his waist and recovered the firearm?
After I saw that that date was expired, then I did recover that firearm.
Okay, you didn't first pat him down.
No,
Okay, you just reached for the firearm.
I reached
and recovered
exactly where I saw the suspected contraband, which was confirmed a gun. It is now contraband because he cannot conceal that.
Okay, so just.
I have no further questions, Judge.
Thank you.
I have no regret. Thank you, Judge.
Thank you.
No further witnesses and the people were arrested.
No witnesses for the defense, Your Honor.
Thank you, Your Honor. The people move for bind over on count one, weapons carrying concealed. Officer saw the L-shaped bullets approached, asked for a CPL. One was provided, it was expired as of 2021, later confirmed through a lien search by that officer. We people have met their burden here, Your Honor. Again, ask for that.
Your Honor, the defense objects to the bind over. First, regarding the stop, it was an unlawful stop. There was no reasonable suspicion to stop Mr. Bell based on, quote, a strong L-shaped bulge. Judge, I think we see it all too many times that these officers testify that they see these L-shaped bulges, which me personally, I don't see how they form the shape of a handgun, but that's besides the point. Even if he did see an L-shaped bulge, that enough does not justify a stop of Mr. Bell's person. There was no other indicia of any sort of criminal activity. Mr. Bell was walking outside with daylight at an event with hundreds of other people minding his own business. The police had no right to go up and stop him based even on this observation. Your Honor, moving on, the officers proceeded to detain Mr. Bell prior to having probable cause that a crime was being committed. They did not know whether or not the CPL was in fact expired at the time that they handcuffed him, walked him over to the vehicle. And Judge, that would be an unlawful extension of the initial stop if this court were to even find that the initial stop were justified. The extension of it, taking him over to their police car to confirm whether or not he had a CPL based on the card that he gave them, would also be in violation of his rights. And finally, Judge, factually, I don't even think that people have met their burden of establishing concealment for purposes of a for purposes of meeting their burden of probable cause at this stage. There was no testimony that the weapon was in fact concealed on his person, that it was somehow being covered by any articles of clothing or in a pocket. I believe the officer, what I heard, I think, is that he just recovered the pistol from somewhere at 2 or 3 o'clock on Mr. Bell's person. So Judge, for all of those reasons, I would ask the courts to dismiss this case.
Well, thank you, Your Honor. As it pertains to the stop and the detainment of Mr. Bell, in this case, Your Honor, the officer asked for a concealed pistol license. One was provided, so the notice requirement was met. However, on the card, the officer stated that he only could see that it says expired 2021. There was a faded card other than that. So at that point, Your Honor, he has reasonable suspicion to believe that this card is expired as of the date that's on the card, which is the license to carry that weapon concealed at that point, Your Honor, has expired. So he's detained at that point rightfully, and they're going to just confirm. The officer testified himself that he was going to confirm because if it was extended, I'm assuming they would have just let him go at the time and after it was confirmed, which they go and he goes and confirms it and lean to find out that it is in fact expired. Your Honor. I believe the people have met their burden because especially going on to the concealment argument in this case, Your Honor, the officer testified that he sees the L-shaped bulge. Doesn't testify he sees the gun, he sees the bulge. And again, so the probable cause conference, probable cause is the standard. If Your Honor would like me to reopen the proofs, I would ask him where specifically that gun was. But I believe that the fact that he said L-shaped bulge implies that it is covered, it's bulging through something, is closing, because he says it's at his hip. Your Honor, I believe the people have met their burden and would again ask for it. Thank you.
All right, we're having heard the testimony and argument as follows. Officer Joshua Denard, who testified on May 27th, 2023, sometime after 7 o'clock p.m. in the area of 21623 Plymouth Road at Roots Park. He was on foot. On patrol, was maintaining peace. There was a large number of people in the park. We observed a male private dependent, which he observed a large L-shaped, a strong large L-shaped bulge on his right side. He approached him, asked him to get a CPL, then it reached in his pocket, pulled out a CPL card, which was somewhat tattered. Had a date of 2021. He then, at that point, detained him, seized the gun, walked him over to a vehicle where it was ran through lean by another officer. He received information from that officer. As a result of that, he then took him back to his car and ran it through lean himself. That the CPL was in fact expired. The L-shaped bulge I understand the argument, and I understand we hear it a lot. But I also have to say, almost every time I've heard it, there was a gun there. I can't remember a time there wasn't. So does that give him reasonable suspicion to approach? Yes. And at that point, you know, he just shows him the Mr. Bell shows him the CPL card. The card is old and tired. It has a date on it that reads 2021. So he has the right to further investigate. He's not arresting him at that point, but he is detaining him. He does have the right to do that. And through that investigation, finds out that the CPL is in fact expired. That thus leads us to where we are today. So based upon all that, the court finds that the felony enumerating and explaining warrant did in fact occur in the city of Detroit. Probable cause is this charge is defendant to be bound over to Wayne County Circuit Court Criminal Division for arraignment on the information, which will be July 11th, 2023, 9 o'clock p.m.
Thank you, Judge.
Thank you, Judge.
Thank you.
May I briefly respond to one of the court's questions or points? It can be off the record. We don't have to call it on the record.
But we don't, yeah, we don't file on the record.
It doesn't need to be on the record. Your Honor wouldn't see all the times that there was an L-shaped bulge that nothing happened.